All right. Let's launch into our next discussion. And I emphasize discussion. That was a great panel discussion. Our last session, I want to thank Asaf specifically for doing what I hope we'll see on this panel as well. And that was very early on, kind of two-fingering on the panel itself, right? Because this is the best way to get dialogue going. So cognitive conflict revisited. Why revisited? Shamelessly, we did a panel on this at our first annual symposium. I had written a paper about sort of the intersection with influence operations and the rule of prohibited intervention in international law, really kind of diving into the concept of coercion and what that means. And I think we'll be unpacking that to some degree here. And that was, for me, initially spurred by, and it's interesting, this confluence between domestic law actions and international law. The Mueller indictment, setting aside any controversies around everything these days, but the Mueller indictment, the gravamen of the offenses there were under a U.S. Title 18 fraud statute, right? That these were efforts by foreign actors to defraud the United States of a sort of free and fair election. So I'm paraphrasing. And it was that fraud and deception notion that intrigued me initially and had me kind of deep dive into that in the paper I wrote. Interestingly, on that panel, we ended up spending the majority of the time not really unpacking the coercion question, but the domain reserve question. And we'll explain that a little bit more here. Hopefully we won't dive down the domain reserve question so much this time. But that was even fascinating itself to sort of look at understandings or evolving understandings of that component of a specific prescription in international law that can lead to state responsibility. We've heard a number of examples so far, yesterday and today. Kubo raised yet another one for me that I'll come back to. But just recently, we have another federal indictment in the U.S. Prosecutors unsealed an indictment in federal district court in New York, charging 2 Russia-based employees of RT, a state-controlled media outlet, of conspiring to commit money laundering and conspiring to violate the Federal Agents Registration Act in the United States. These employees, implementing a $10 million effort to essentially push through that media Russian narratives, et cetera. We talked yesterday about the actions against RT and Sputnik in France and the European Union and so on, and the implications of this from a human rights perspective, freedom of information, et cetera, freedom of expression. At the same time, the Justice Department seized 32 internet domains that they allege the Russian government and pro-Russian actors used to engage in what the Attorney General called a covert campaign to interfere and influence the outcome of our country's elections. Very fascinating statement from the Attorney General when announcing this. The American people are entitled to know when a foreign power is attempting to exploit our country's free exchange of ideas in order to send around its own propaganda. Number of sort of concepts and terms, I think, buried in there that we will talk about and how they interact with these various frameworks of international law, state responsibility, the intersection in this case, I think, with human rights, et cetera. There are other examples. I can speak only to what is in the public record on this one, but it's been, reported several times that in the lead up to the 2018 midterm elections, Prigozhin's Internet Research Agency had some challenges accessing the internet, right, to use the troll farm and to disseminate campaign or election interference information. Here's a moment of true convergence. If you take those reports as accurate, where we have the efforts to conduct malign influence and interfere potentially in the elections of another state, and that state responding at least in part through cyber effects operations to counter those efforts. So that's what we want to unpack. And I will say, your question, Kubo, about supply chains and trust intrigued me. And you know, you don't even necessarily have to actually compromise a supply chain. You can simply plant the seed of doubt through information operations that a supply chain may not be reliable to create the same impact on trust, et cetera. So what are the international implications of all these things? So joining us to talk about all this, we'll start with our online guest. And if there's, am I allowed to say why you're online, Talita?
Yeah, that's fine, Gary. I think most people know.
Because you couldn't be here today, so you're online. But and we're lucky that Talita can join us even online because she is an imminently expected mother. So congratulations, Talita, for that.
Yes, very imminent.
So Talita is a senior research fellow currently in the International Law program at Chatham House, formerly at Oxford, a thrice participant in this symposium, a friend and someone who's done a lot of great work in this space. Jack Kenny, I'm not going in any particular order here. Obviously a research leader in international law at the British Institute of International and Comparative Law, has published a number of very interesting and I'd say provocative or challenging pieces in this space. Amit Schejter, I get it right?
Pretty good.
Visiting professor, I had some help, I was coached. Visiting professor, co-director of the Institute for Information Policy at Penn State University's College of Communications. I first met Amit in this room for TPRC. What does TPRC stand for?
Well, it used to be called the Telecommunication Policy Research Conference, but a few years ago, we figured out that telecommunication is a meaningless word. So now we just left the acronym. So it's TPRC, the Conference on Information, Communication, and Internet Policy.
When I asked Amit,
you're all invited next year, of course.
You're all invited next year. When I asked Amit to join this panel, he sort of scratched his head and said, why? I think it'll become apparent. And I'll say that just the way we're going to flow the discussion, he'll be chiming in later probably than earlier in the discussion, but this interface between state responsibility, international obligations of interstate relations, and human rights, and the notion of freedom of expression and how anonymity plays in this equation. And Amit has done some very interesting work, published some really fascinating papers and things on the role of anonymity in relation to the right to receive information, which is a very different way of thinking about it, right? So we'll be drawn on that. And then my good friend, Robert Young, Deputy Director, you've heard from him several times already with good effect, of the Criminal Security and Diplomatic Law Division at Global Affairs Canada. So there's now in US law a definition of foreign malign influence that's in there to drive certain legal provisions, other legal provisions, the remit of organizations that have stood up, for example, within ODNI to track from an intelligence perspective, different influence activities, but hostile efforts undertaken by, at the direction of, or on behalf of, or with the substantial support of the government of a covered foreign country with the objective of influencing through overt or covert means, A, the political, military, economic, or other policies or activities of the United States government, or state or local governments, including any election within the United States, or B, the public opinion within the United States. That's a pretty broad definition of malign foreign influence. And interesting in the sense too, that recently, for example, we very openly called into question the legitimacy, for example, of the elections in Venezuela. So I think what it all sort of raises when we get into the influence space is activities that states have been engaged in historically since the advent of states, right? Suasion of some type to influence the policy decisions, activities, et cetera, of other states. I think that in large measure, this area of propaganda, et cetera, falls very much in the same category of espionage, where whether you describe it as international law tolerates it, international law doesn't prohibit it. But is there a line where those activities cross from acceptable, albeit sort of unwanted or hostile, into unlawful as a matter of international law? And has technology changed the face of this? So I'm going to turn first to Jack. Is there something different now? What is the difference between traditional dissuasion, persuasion, propaganda that states engage in, accept as part of the game, so to speak, of statecraft with our many definitions? Or are there international legal implications to these influence activities? It may be dead, so share one with, sorry. Yeah, go ahead with that one.
Thank you. Well, thanks, Gary, and my thanks to the organizers for the invitation. It's really great to be here and to have the opportunity to listen to so many interesting discussions. My work focuses mainly on the application of primary rules of international law to cyber operations. And this year at BICL, which is a long acronym. Yesterday, somebody said they had a long acronym. I think BICL was quite long, but I know people from CCDCOE are also here. So, I'll take the title for now and perhaps pass it later. I've been leading a project on looking at underlying normative issues relating to the application of international law to cyberspace, and I suppose to new technologies more generally. When we discussed the panel with Gary, initially he gave some examples of disinformation campaigns or influence operations which were carried out by states. And really we were talking about elections, I guess, some of the examples, and in particular the US elections. And given the focus of my work, I'll briefly set out some of my ideas on the application of primary rules in relation to these interference operations in the context of electoral interference. I'm sure this panel later will touch on sovereignty and obligations of conduct, which I'm also happy to share my views on. But in my opinion, when we're talking about influence operations and elections, it's the principle of non-intervention which is the most relevant for these examples we discussed. And indeed, when you look at the large number of state positions, and there's an increasing number of them, and Kubo's here today, but the cyber law toolkit very neatly organizes these. It's often the rule which states most frequently refer to when they are discussing and setting out their national positions in relation to the application of international law in this area. So as we moved through this discussion in our pre-meeting about the panel, it made me think of this chapter I wrote a couple of years ago, although it was very long to come into publication, only last year, I think. But I was looking at advanced artificial intelligence techniques and the principle of non-intervention in this context of electoral interference. And in the chapter, I made a distinction between direct forms of interference, so perhaps cyber operations targeting elections infrastructure or systems related to, for example, voter tallying or counting, those systems directly, and indirect forms of interference, so influence operations perhaps seeking to influence the electorate more broadly in terms of how they vote. And I did this based on analysis of state positions and academic debate. And a number of states have recognized the application of the principle of non-intervention to scenarios of electoral interference, which are these direct examples you often see crop up. But it's much more complicated when we're talking about indirect operations where it's influencing voter behavior. And this is really what the panel, I suppose, is interested in. So for those of you that aren't familiar with the principle of non-intervention, it's an established rule of customary international law. And really, we have two elements required for a prohibited intervention. Firstly, as Gary mentioned, we have this element of domaine reservé, which is that the activity in question must bear on matters in which each state is permitted by the principle of state sovereignty to decide freely. And I don't plan on going too much into this in the context of electoral interference, because it's this second element which has perhaps drawn more attention in the cyber context, which is that the methods in question must be coercive in nature. And coercion, therefore, plays a critical role in defining a prohibited intervention. And it's said that it regulates the line between mere interference, which is not necessarily considered to constitute a violation of international law, and this prohibited intervention. In the cyber context, we often hear this second element, the coercion element, as it's being discussed in this way where it's quite demanding to satisfy. And therefore, maybe we need to look more at sovereignty and how that relationship between sovereignty, whether you have a debate between it being a rule or not being a rule of international law, which is applicable to low-level cyber operations. And this demanding characterization of coercion is based on this definition where coercion requires forcing a state to act in an involuntary manner or to involuntarily refrain from acting in a particular way. But in my research, I think I would challenge this narrow definition of coercion. During my doctorate, I worked on the Chatham House paper on sovereignty and non-intervention, which some of you may be familiar with, written by Harriet Moynihan. And this paper took the position that rather than forcing a state to act in an involuntary manner, coercion is capable of a more broad application where all that's necessary really is to require a degree of pressure to deprive the target state of control of its state functions. And this was the conclusion I came to in my research. So Gary asked, what are the new challenges really that are presented by this new technology? And I think that's really the key question. Yesterday, we heard some presenters rightly make the case that, well, none of this is new. We've had propaganda for a very long time. We've had disinformation for a very long time, different methods. So when you're looking at new technologies and the application of, or the use or deployment of advanced artificial intelligence techniques, I think while these methodologies don't necessarily, they don't change or alter the criteria on which coercion is evaluated, they do amplify the scale of effects that are possible to achieve, which increases the likelihood such activity could interfere with a democratic state's inherent right to run free and fair elections. And the paper and some of my research goes into the weaponization of technologies such as deepfakes, which we heard about in the keynote yesterday, but also activities harnessing scale and anonymity, which I think the panel will perhaps delve into more. For example, creation of a vast number of fake profiles on online platforms using artificial intelligence to populate their content, which can influence an electorate and create this herd mentality. There was an interesting reference yesterday by one of the panels to not just directly influencing voter behavior, so in terms of swinging a vote perhaps to a different party, but also beyond changing the behavior in this manner. Imagine a scenario where, for example, on the eve of an election, an incumbent head of state might appear to announce that an election was cancelled or postponed, or that the individual was conceding or withdrawing from a race. And if you have a deepfake video propagating this, which spreads virally online, it might result in a large number of voters not turning up. So it's not just necessarily influencing a voter swing one way to another party. And when I was looking at this chapter, which I wrote some time ago now, I was looking at real world examples I discussed in the paper. I think one incident was I referred to as in Malaysia, where a video purporting to show the Minister of Economic Affairs engaging in a sexual encounter caused significant reputational damage. But last night I had a look around to see if there was any more examples of real world practice. And there are a number since the paper's been published. a video of Moldova's president throwing her support behind a political party friendly to Russia, audio clips of Slovakia's Liberal Party leader discussing vote rigging and raising the price of beer, a video of an opposition lawmaker in Bangladesh, a conservative Muslim majority nation, wearing a revealing swimsuit. These are all operations that have been reported for discrediting political opponents. But when you look at mainstream media and the way that we've been warned so many times now, I think 2 US elections back even, about the impact that deepfakes are going to have on voter behavior, we see that haven't really materialized. And experts seem to think this is because at the moment, primitive forms of influence operations still really remain effective. But we have seen also that deepfakes and technology used in terms of their availability has really come a long way. You know, we've all seen convincing videos, and we heard the example yesterday of how effective they can be when they're deployed in the right way. We've also seen instances in the criminal context, for example, widespread uses of voice cloning to perpetrate scams, fraudulent activity to generate money in that way. So these technologies are rapidly developing and increasingly available. And we also know that states are extremely active in this area. A 2020 report by the Oxford Internet Institute found evidence of 81 states using social media to spread computational propaganda and disinformation about politics. So really, where does this leave us then? Well, if coercion is understood to require a degree of pressure, so if you accept this broader definition of coercion, which I think is largely correct, to deprive the target state of its control of its state functions rather than forcing a state to act in an involuntary manner, I think the scale of effects that are possible to achieve through the use of these new technologies, such as artificial intelligence techniques, they really challenge the understanding that mere influence operations alone are not capable of being coercive, and that raises the possibility that some influence operations may be capable of constituting a prohibited intervention. And obviously this goes straight to the definition of coercion and where you fall on that broader or narrow scale of things.
Yeah, so you've as sort of suggested in your remarks that broader understanding of coercion is what you think the state of the law is. I will confess, it's generally where I try to land. What is lex lata, not the land of lex ferenda? But when I wrote the paper, I struggled on that. One of the threads of the examples that you've given are all about some level of deception, right? Deception as to the provenance of the information, deception as to the content of the information, et cetera. And for me, that seemed to be a dividing line between what traditionally is accepted. And I think sort of normatively, if I know who the speaker is, if I know it's a foreign leader, I can engage with that information as a citizen very differently than if I'm being duped, right, as to the provenance of the information. But whether I was arguing for looking to, my paper focused on sort of general principles common to states in criminalizing or giving legal sanction to means of fraud and deception, either directly or as substitutes for coercion in many circumstances, constructive force, right? Is that a lex ferenda argument, or is that just an argument for an interpretive tool for the current understanding of coercion? So where do you, just to unpack that a little bit more maybe, and looking, I mean, there's no question, I think historically there was definitely more of a correlation between force and the notion of coercion in the rule of prohibited intervention, and has that evolved to sort of break away from that?
Yeah, it's a great question. I think and we've had discussions about lex ferenda and lex lata. I mean, I suppose we align on some issues in relation to that. I do feel very strongly that in the cyber context, when you look at how certain rules, or indeed whether they are rules, are discussed in that context, and then you take it more broadly outside of the cyber context, I do think there's a big distinction there. For me, I see big differences there. I think I see a lot of lex ferenda discussions in the cyber context. When you talk specifically about coercion, one of the things which we tried to do on that paper, which was very early on, years ago now, we looked for the definition of coercion outside of the debate in cyberspace, and this is where we drew our degree of pressure definition. But of course, when you look at the literature in the cyber context, you see time and time again this intent to focus on it being a very demanding element. It needs to be forcible, and then that we should look towards, for example, sovereignty and a role that might play. So in my research, I try to examine relevant norms of international law outside of the cyber context and then apply them without looking too much at the debate, which I think is in some instances quite contrary. I won't go into sovereignty here, but I feel very strongly that, for example, the sovereignty debate in the cyber context is very unusual. If you talk to experts of international law about sovereignty, which is one of the things that my project this year has done, and explain to them what's happening in the cyber context with the debate about it, for example, being a rule, that's very confusing for those experts, even though they have written a lot on sovereignty and the status of sovereignty.
Yeah,
it gets into that lex ferenda, lex lata.
I think many folks in the room know of my relationship with the sovereignty question. So I think we can unpack that a little bit more, but let's stick on the prohibited intervention trail for a moment. And the real challenge point, I think, is what is the dividing line, right? When we say some form of pressure, sanctions are a form of pressure, right? There's diplomatic wrangling all the time. There's quid pro quo discussions between governments. Is there something more? So just ponder that for a second. But Rob, what are your thoughts? And I know this is something that Canada's been dealing with the problem of malign influence issues as well. So
sure. Thanks, Gary. And thanks for the invitation. I do want to talk about sovereignty, but I will get back to.
Can I mention one thing though?
Yeah.
I'm looking at Rob's notes up here as he's furiously writing things, and it looks more like a Rorschach test. I don't know how you can make anything out of that. That's amazing.
Let's see. Preliminary remark number 1. I'm going to make a comment on the title. So cognitive conflict revisited. Gary just explained. I mean, that's the theme today, isn't it? Right? We comment on the title. Gary reminded us that there was, well, first of all, revisited. I actually don't recall the original visit. Gary has reminded us there was a panel 2 years ago. I was here. I had a great time, but I don't remember that. So I feel a little bit like I'm stepping into the discussion, like going into a movie theater for the sequel, and you're sitting down, but you haven't seen the original one. So I feel like I'm at the Superman sequel, and I'm sitting down in the theater. I know that kryptonite is central to the plot, but I don't quite remember why kryptonite is central. I kind of feel that a little bit about jumping to a discussion on intervention. So in Canada, in the work that I do at the Foreign Ministry, we're thinking a lot about malign information operations, like every day. A small team of lawyers are doing it. My colleague Emily Tsui is here as well and works with me on this. We think about it for elections and beyond elections. Right now in Canada, there's a public inquiry going on into foreign interference into federal election processes and democratic institutions, and it's headline news. It's big news because of documented foreign interference and questions about how the government responded, what it knew, when it knew, what measures it took when there is evidence in the hands of our intelligence community about foreign interference. So it's very big, but I would say we're often looking at it beyond elections. We're looking at it in ways, I think, as Kubo mentioned, how it affects trust, or as I think as Svetlana mentioned yesterday, how it affects sort of minds more broadly and not just elections, even though elections is front and center. But look, we're thinking about these questions when we're in our work, maybe I could offer those insights, operations directed against Canada, where Canada is, if you like, the target state. We're looking at, secondly, how do we respond lawfully to those increasing number of operations? And of course, we have to figure out how we characterize them. And apart from that, how do we deliver cyber ops lawfully, not in response to others, but to pursue other national interest objectives? So for all of those, we're looking at the relevant law. We have a framework for attribution, and we sometimes make public attribution statements. And if there's time, I'll maybe respond to some of what Lee said about that this morning. And part of our job in the Foreign Ministry Legal Unit is to provide advice to our Foreign Signals Intelligence Agency on their cyber ops, because I won't explain the legislative framework, but it falls to the Foreign Ministry. So in all of that, sort of with respect, I would say that while we're talking about non-intervention and revisiting that, I think that maybe outside of London, most of the world, most states at least, in my experience, when they're talking about this kind of foreign interference or malign operations, start talking about sovereignty. I think we can have a longer discussion, but whether or not sovereignty, the international law experts I know who think about sovereignty aren't surprised that we're talking about it in relation to foreign intervention. So maybe we know different experts, or maybe I need to do more reading. So with respect to sovereignty, of course, I think we're talking pretty quickly about interference in inherent government functions. But jumping back to where you were, we also are analyzing all of these activities in relation to the rule of non-intervention. And of course, looking, as you did in more detail a couple of years ago, at domaine réservé, and then looking at coercion. The third, maybe come back to coercion as well, and where the threshold is. But the other point I want to mention discussion is with relation to international human rights law and freedom of expression. So we've been thinking about that a lot with respect to foreign cyber operations or influence operations. Particularly in the first instance, how does it affect Canadians and Canadians' rights, which is governed by domestic law? We have a Charter of Rights and Freedoms as part of our Constitution. But particularly, we've been thinking about response options and how, or if and how, international human rights law may constrain responses that Canada can do lawfully to respond to those operations. And in particular, what about the interplay between a foreign state's obligations to its own population and their freedom of expression rights, their rights to receive information, and domaine réservé, and finally, whether there's state responsibility if in responding to another state's activities, you may be touching upon their population's rights. And I think I just mentioned before stopping, is it Article 51B of the Articles of State Responsibility that countermeasures can interfere with human rights, in simple terms. So that's something I think we've been doing about it. I want to kick off with.
Okay, excellent. Yeah, I think one of the difficulties or the challenges for government legal advisors and policymakers is always the interplay between, for lack of better terms, the who shot John moment in these issues. Must you characterize what's happening to you as internationally unlawful to open the response options that you might have?
Precisely.
Or are the response options themselves within a measure of lawfulness, which also is directly related to some of the questions and debates around sovereignty. I want to offer up to the other panelists if they have thoughts or want to interject on this discussion about the nature of influence operations themselves being violations of some rule of international law or not, which obviously then influences the response options we'll come back to.
Yep.
And I know, Amit, this is not your primary area, but so you're free to interject, obviously, anywhere you want. But maybe, Talita, did you have any reactions to what you've heard so far?
Yeah, so I agree with Rob that instinctively sovereignty would be the first rule at play here. And obviously influence operations of that kind that potentially violate non-intervention would almost automatically violate sovereignty, if not on the basis of the effects of the operations on the territory of another state, on the basis of the fact that they are undermining inherently governmental functions, right? So that's that second limb of that test for assessing whether sovereignty is violated in this particular context, in the cyber context. But also on non-intervention, I really don't see the the difficulty of considering indirect forms of interference as violations of non-intervention. And this is because historically, non-intervention includes both indirect and direct forms of coercion. So if you look at the Friendly Relations Declaration, if you look at other declarations by the UN on the same topic, so there's one called the Declaration of the General Assembly on the Inadmissibility of Intervention and Interference in the Internal Affairs of States. There is a specific mention of a duty of states to abstain from any defamatory campaign, vilification, or hostile propaganda. So hostile propaganda, even without deception, could be a way of violating the principle of non-intervention. So, and I agree that with Jack that the threshold is not that high for violating non-interference, but I also don't think that we should make a big deal out of these distinctions between deceptive, information operations and non-deceptive. I think what really matters is whether or not, in the particular circumstances of the case at hand, the state in question, the targeted state, had its ability to control its internal affairs, its freedom constrained by the foreign state. So to me, that's really the bottom line. And as I think that Rob mentioned, we might also be seeing as a violation at play there, violation of human rights and international human rights law in particular, right? So, of course, that would assume that human rights apply extraterritorially. So if you are, and the example that you gave, Gary, if you think that by mounting a disinformation campaign against US citizens or people in the US, Russia has violated international human rights law, you have to accept that international human rights law applies extraterritorially. So you have to accept a more flexible conception of extraterritorial jurisdiction there. What is interesting about human rights here, and in particular freedom of expression, is that it's got this dual dimension, this dual nature of an individual component where individuals have the freedom to impart information and ideas of all kinds. And also you've got that social or collective dimension of the right to freedom of expression, which I'm sure Amit will go into. That's to enable, really communication, a two-way communication between individuals and society. And so in the scenario that you described, Gary, the influence campaigns would, so first of all, Russia doesn't have a right to spread false information. Individuals do have a right to impart information and ideas of all kinds, including to lie to some extent, though this right is not absolute, as we'll probably discuss, along the way. But Russia doesn't have such a right to spread false information. And Russia and other states, for that matter, must also refrain from spreading false information, because they have to respect the rights of US citizens to both to receive information in that context. So you have here the collective dimension of the right to freedom of expression, the right to receive information specifically. So that's what I wanted to add to the discussion, the potential violation of international human rights law in this context also, but of course, assuming that these rights apply extraterritorially, which might not be in line with the US conception of human rights jurisdiction in the past.
Yeah, very good. And Rob, I know, wants to respond here. I don't want to turn this, and Amit, this is good. I don't want to turn this into an extension of the sovereignty debate necessarily, but I do want to give Jack a moment to sort of respond to some of the points on sovereignty. But Amit, you haven't had a chance yet, so.
Oh, okay, well, it's fine. I can go next if you would like to stay with the issue of sovereignty. It's not one that I
want to go back to extraterritorial application of human rights.
Sir,
can I do that?
Sir, you may.
Okay. So Talita, your last comments were about assuming the extraterritorial application. I want to talk about assuming there is no extraterritorial application, but then the question I'm asking is, but are human rights a factor in this discussion? So I mentioned Article 50.1b of the Articles on State Responsibility that says countermeasures can affect the obligations for the protection of fundamental human rights. So let's say a foreign state is spreading serious disinformation that Canadian wheat is poisoned, and we're a major exporter of wheat. So this is affecting Canadian wheat sales in, let's say, our primary markets in sub-Saharan Africa, let's say. So we want to counter that. It's false information. But in order to stop the foreign state from spreading that information through its covert means in populations in sub-Saharan Africa, we want to block that. To block that, are we possibly interfering in our countermeasures, which are lawful, assuming there's a prior unlawful act? Let's say that disinformation is, assume it is. But if we, encountering it, are going to interrupt the communications of this disinformation about Canadian wheat, does Canada have to be concerned that we're interfering with some people's rights to receive information, whether in the state that's responsible or in the states where wheat is being consumed? That's where I'm interested. So assuming it's not extraterritorial application, but do human rights matter in this scenario?
I would say they matter, but to what degree and how,
Yeah.
we can unpack further. Go ahead, Amit.
Yeah, so I actually am going to talk about something I didn't prepare. No, which is because the discussion is going in a direction that I like, because it's something that I think maybe I can contribute, or some new idea into this conversation. I think that the term you mentioned now is kind of what brought me into this, where you're saying that we have to look at the total communication that's involved. In my work, and I will preface by saying that I do have a legal background. I went to law school, and I even worked as a lawyer. Sorry to say, but as you can see from the way I'm dressed, I don't do that anymore. I'm a professor now, and I can do whatever I want, a professor of communication. So the idea I've been toying with for the past few years, and this discussion of anonymity, which you brought me for, is tying to that, is that the way we have created, structured the notion of freedom of expression is antiquated, is wrong, and should be rethought, especially in light of contemporary communication technology. Well, we all, lawyers here, deal with freedom of expression, so we all know that where the source of the idea of freedom of expression came in the 17th, 18th, 19th century, with ideas of uncovering the truth and so forth and so on. That's a great idea. I'm not against it. But expression is only one aspect of a whole process, which is the process of communication. And in communication, there's not only those that deliver messages, there's also those that receive the messages. There's also a channel over which the messages are transferred. Right now, it's just the air, but it could be something more sophisticated than that. And of course, there's the message itself. And all these elements create a totality of a communication process. And what needs to be protected, or before that, I would say, human beings cannot survive without communicating. It's as basic as eating, as having shelter. If you cannot communicate with the environment, if you cannot communicate with others, as we know, we make an effort to those that have difficulty in communicating to overcome those difficulties and those handicaps, because without communicating, you cannot function in a society and you cannot survive. So the right that needs to be protected is not necessarily only the right of free expression, but the total right to communicate and to be engaged in the process of communication. So, for example, in this action of interfering with elections, and maybe the fear that by stopping some Russian propagandists from interfering in elections in another country, we are maybe breaching the right of free expression of that particular, if it's an individual. I mean, if it's a country, I'm not even getting into that aspect of it. We should also look at the rights of those that are receiving that information. And therefore, we don't have to, in my eyes, and this is something I'm working on now, which anonymity is part of it. In my eyes, we have to look at the totality. We don't have to look at free expression separately or freedom of information and say that it's justified because it helps expression and then all kinds of, no, the freedom is to communicate. And to communicate freely also requires that the message, for example, is not distorted. And so in order to ensure that messages are not distorted, we are protecting the right of the individual that is receiving the information. And protecting those that are receiving the information is as important as protecting those that are conveying the information. And therefore, it's more of a broader look at what it is in the process that is taking place. I'm not getting into the issue of sovereignty, which I don't know how we can enforce that on another country, but the question of, are we breaching somebody's right by the fact that we are blocking or somehow dealing with the information coming in, is that we have to look at the rights of the voters in our country, right? In the place that is receiving this information, and to say, is their right to express themselves in that sense, okay, as in a free election, is that being breached when they are receiving information that is skewed or distorted in any way?
Yeah, and there's I want to come back to this, but there's somewhat of a fundamental clash of interests, at least if I look as a reference point to US law, which obviously that's just the United States, but in the area of freedom of expression, use the more traditional term, the inapt term, anonymity is viewed as a legal interest to be protected in that space for the communicant, right? Those cases have always come up where there's efforts to unmask the identities of people who are parts of certain organizations that might suffer retribution for that. People who are in places where there is authoritarian regime, censorship, et cetera, the ability to actually engage in, especially the core protected area of political speech, requires a degree of anonymity. But to your point, right, there's also an impact on the recipient that seems to me to play in the exact opposite direction.
Right. And so anonymity, as we see it, is first of all, is a derivative of two rights. It's free expression and also privacy. So there's two aspects to it. And that's why also when we look at anonymity, we can differentiate between what we see as active anonymity and passive anonymity. Okay, there is passive anonymity is more related to privacy. Okay, as in the old days we had that cartoon, right? Says nobody knows you're a dog on the internet. But now we have a new cartoon that says don't you miss those days when nobody knew you were a dog on the internet, right? Because you go on the internet and somebody knows who you are. Okay, so you're not, there's no anonymity, there's no real anonymity anymore, at least for innocent users like the people in this room, not people with criminal intents. So first of all, so passively, you want to be private and you want to protect certain aspects of your communication. In parentheses, I'll say election is one of these things too, right? You go into the voting booth and you don't want anybody to know who you voted for. So there's both privacy and freedom of expression that are protected there. Now, the active act is or the active aspect of anonymity is when you want to say something or do something and not that other people will not know that you are doing it. So the question is, why do we protect that? Just recently, I mean, I was communicating with my co-author on this work. There is, of course, now the case with all the demonstrators who want to come with masks, and certain universities in the U.S. Are now not allowing to go unless you have a medical reason that you can prove why you're wearing a mask. You're not allowed to enter the campus with a mask. And that's because of the events of the past year. Now that's and then there's a whole issue of doxing and all those questions that raise all kinds of concerns of what we call the active aspect of anonymity. In other words, what are you allowed to say and be protected? So some of these and as in all issues of human rights or other rights, it's all a matter of balance. Okay, so it's why are you being protected? So, for example, we protect, again, in my field of communications and journalism, we protect the sources, right, of journalists, because we want to make sure that people can tell something and then not be afraid to tell, that there won't be any retribution. Again, in different countries, it's protected in a different way. In the US, it's protected in different states in different ways, but there is a level of anonymity that we protect there because we think that it's important to have whistleblowers that uncover government corruption. But if the intent of the person that is speaking is such that to begin with has what we would call a negative intent or a bad intent, or whatever they are, the information that they're conveying is that the wheat in Canada is poisoned, then what kind of right exactly are we protecting? I mean, who are we protecting in this process?
Yeah, I think to your point, and again, I'm drawn to analogies of what I know, but in U.S. First Amendment law, we talk about reasonable time, place, and manner restrictions on speech, which is obviously protecting the interests of others, not in balance with the rights of the communicant. So the mask wearing, for example, there's worries about risks to others that come with that, and the ability to identify who may be engaged in criminal activity or not, or et cetera, right? And it does seem to raise the question, if you look at Article 19 of the ICCPR, and there are exceptions there, and one is the protection of national security and so on. There's obviously more to that, but and how does all this play into that? I want then we've already talked about, there's the question of whether your own information operations, separate from the questions of state responsibility in the form of prohibited intervention or perhaps sovereignty, which Jack can talk to in a minute. Are you violating human rights by the dissemination of the information itself of the targeted audience? That's something maybe also to be talked about. We've talked about remedies, the tendency to move towards self-help remedies in international law now because of the deficiencies of enforcement mechanisms. Are you able to invoke countermeasures when human rights law provides, through treaty and otherwise, the mechanisms for dealing with or responding to violations of human rights? Right? That's I think a question of whether the aptness of countermeasures comes into play there. But we have been talking a lot about countermeasures. So, Talita, this is all, maybe you could kind of detail out a little bit more and how you've thought about the interrelationship between countermeasures in the area of responding to foreign state interference activities and the law of countermeasures.
Sure. So, like you were saying, countermeasures are just one response option, right? And an accountability toolbox, if you will. Of course, they are important remedies because of the decentralized nature of international law and its enforcement. And so states have very few options when it comes to responding to unlawful acts, including unlawful information operations. And so countermeasures naturally arises as one of these very attractive options, right? But the conditions for taking countermeasures and the purpose of countermeasures are so specific that they might not necessarily be the most a popular measure that states effectively resort to in these kinds of scenarios. So while we are instinctively driven to think that, well, let's respond with countermeasures, it's actually not a very common remedy in the cyber context as of yet. And that's what I found, for example, in my research, trying to find, examples of state practice of countermeasures in the cyber context. And so along countermeasures, and I can go into the conditions for that, and in particular, the condition that Rob mentioned, which I think is really important in this scenario, the condition to not affect fundamental human rights. There are other conditions that make the taking of countermeasures quite stringent. But in addition to countermeasures, you've got domestic remedies, you've got law enforcement action, which I think is the case of the measure, Gary, that you have referred to, or the measures that you have referred to at the beginning in your introduction. Basically the charges that have been brought against those two RT employees, as well as the seizure of the 32 internet domains. I don't think that these are countermeasures. I think that they are domestic law enforcement action basically of a criminal nature, criminal investigations and prosecution, because they're not really targeted at a foreign state. They're not directly targeted at Russia. They seem to be targeted at individuals acting on behalf of Russia, but the attribution link is not very clear. And also, what is most crucial here is that countermeasures they have to be, they're measures that violate international law. That's the whole essence of countermeasures. Countermeasures are measures that would normally violate international law, but their unlawfulness is precluded because they are basically, with them, you're righting a wrong, right? And so basically, if the measure in question is not a violation of international law in principle, it can't be a countermeasure. And that's why there is a lot of confusion, especially in the cyber context, as to whether or not a certain measure is a countermeasure. Does it violate international law? Does it not? And so that's really a problem in terms of identifying what really is a countermeasure. So, but alongside that, you've got measures of retortion as well. So cyber intrusions, for example, that don't violate international law. For example, pure intelligence gathering operations. And then something that is very often mixed up with countermeasures are treaty exceptions. So for example, measures that are allowed as an exception by a specific treaty, for example, trade restrictions in the context of the WTO or the GATT, Article 21, for example, security exceptions. So it's very easy to mix countermeasures with other remedies. And we need to be alert not to think that, or cautious not to think that everything is a countermeasure. But countermeasures obviously have their value. And I do think that in the context of the 2018 election, in the case of the operations, or the cyber operations, the cyber intrusion and disruption operations that Cybercom mounted against the Russian intelligence research agency in 2018, those could qualify as countermeasures, because they seem to be violations of, again, sovereignty, at the very least, perhaps non-intervention of Russia, prima facie violations. They were directed at Russia, and they seem to be compliant, at least on their face. They seem to be compliant with the other conditions for taking countermeasures. So they seem to have been proportionate measures. They seem to be measures adopted for the purpose of stopping or remediating or redressing a breach of international law. There was some sort of prior warning or prior demand against the Russians to stop the information operations before that campaign, that cyber operation, disruptive cyber operation, offensive cyber operation against IRA was mounted. And so I think that operation had all the hallmarks of a countermeasure. And going into the human rights component, as Rob said, any countermeasure must not affect the fundamental human rights. Now, there is a lot of debate as to what that means exactly, and I won't go into the weeds there because, I will take the whole panel only with that. But basically, the crux of the matter is, first, what are the human rights, the fundamental human rights that are protected by that clause? So what human rights must the state not affect when taking countermeasures? And also, does that obligation to respect or protect human rights or not to affect human rights, does that extend beyond a state's existing human rights obligations? So these are the two controversies. The view that is most widely accepted is, at least as a minimum, states have to comply with their existing human rights obligations when taking countermeasures. And so if states have an obligation to respect and protect freedom of expression and freedom to receive information, then whenever taking a countermeasure, they must make sure that any limitations on individuals' freedom of expression and freedom to receive information complies with the test for limiting those obligations. In the case of the ICCPR, the International Covenant on Civil and Political Rights, Gary, which you mentioned, you've got the requirements of legality. Basically, any limitations need to be grounded in law. You have the requirement of legitimacy. You have to adopt that limitation for a legitimate purpose. In this case, it could be national security. And most crucially here, these limitations, they have to be necessary and proportionate, which I think goes to the point that Amit was making, that balancing of rights and making sure that any measure is calibrated to achieving that legitimate aim, and it's not excessive in the circumstances. So that's basically, in a nutshell, how countermeasures fit within this picture, this messy picture that you laid out, Larry.
Yeah, thank you. That's a very, very large nutshell. No, but it's excellent. So here's part of the challenge with this is the circularity in analysis all the time, right? So fair enough to look at, and we don't know all the facts about how that operation was executed. And if we do, we're not able to say, right? But fair, that's a limitation on how much we can deconstruct what happened in against the Internet Research Agency. But to say it was a countermeasure presumes, right, that what Russia, the Internet Research Agency, attributing that to Russia, first of all, was doing amounted to a violation of international law. And I think attribution questions muddy that issue, because was the Internet Research Agency a private entity that just happened to be aligned with the interests of Russia in that case or not? Because, right, non-state entities, unless they're under the effective control, et cetera. So you're kind of falling back onto the sovereignty question in the circularity of the analysis. I will give Jack a minute or two to maybe respond to some of that discussion. But then also, you come back as well to what does it mean then to not affect, as you said, Talita, right, the human rights question? And does the anonymity of the communications, the deceptive nature of the communications, factor into your balance analysis under the exceptions in Article 19, and how and why? So, Jack, over to you first.
Sure, thanks. I should say I agree with many of the points Talita made on the broader understanding of coercion and on countermeasures also. Obviously, much of the discussion around countermeasures depends on your position on the application of primary rules. So as you say, it's very circular. And depending on where you position yourself there, you end up with more operational freedom or less operational freedom. And so that plays into, I think, how you hear states discuss countermeasures and their positions. Obviously, I'm not privy to state level discussions at perhaps the same level, but I have been fortunate to have involved with quite a few roundtable discussions where you have legal advisors. And I've certainly spent too much time looking at state positions on the application of international law to cyberspace.
Kubo would say you can't spend enough.
Yeah, I would say you can't spend enough time. Yeah. I think it is at least as far as I know, it's fair enough to say that electoral interference or interference in elections, when states are discussing it, at least in those national statements, they are often doing it in the context of a period of intervention, and less so in a direct link with sovereignty. I think that's fair to say. I completely accept that lawyers in the cyber context are not surprised by sovereignty being discussed as a rule. I feel very much in the minority pushing back on that. My point was more to look at the discussion and the definition of sovereignty outside of that context, and then its relationship in cyberspace, which is sort of what's been the focus of my research. And I'm talking here about scholars of international law, practitioners of international law from around the world, who are often confused when you talk about sovereignty in such a specific manner, being discussed as a rule of international law, which if it's violated, is capable of establishing state responsibility. And then you get into the problems, obviously, with defining sovereignty, even if you accept that that's however you want to frame it, as territorial sovereignty, or you want to define sovereignty, that becomes problematic, in my opinion, whether you're talking about inherently governmental functions. But however you're doing that, that for me is you are developing the law as opposed to lex lata, applying the law, which in itself is an interesting discussion. You know, are we developing a rule, a cyber-specific rule of international law? Then for me, you'd have to look at state practice and opinion juris. And Yuval's here, who is my examiner, so I feel like I'm having flashbacks to my thesis examination here on sovereignty. I think I align perhaps with, for the most part, on your position, Gary, which is obviously very well put forward in the document, on your papers. But I would, I guess, I would even push back on the presentation of sovereignty as a rule versus a principle. I find this a really strange framing. I think this is only something you see again in the cyber context. I agree completely with the position that it's sort of an underlying concept of international law, but even describing it as a principle of international law is very, very controversial among international law scholars that aren't working in the space. So I would say it's even vaguer and more broad than that. I've been doing a number of interviews and discussions and roundtables and workshops in this research position that I'm in now, and we're publishing a paper at the end of the year on this. But more than once I've been told by a scholar, you can teach a whole course on public international law and never mention sovereignty, which I always think about when we're having these specific discussions in cyberspace. And I guess the final thing I would say as well is that I guess in addition to that framing of rule versus principle debate, I would also push back slightly on the discussion around state positions on sovereignty. It's certainly true that increasing numbers of states in their national positions recognize sovereignty as a rule in the context of cyberspace. Absolutely. But I push back slightly on this idea that is often represented as the UK being the sole outlier against that. I think if you spend as much time looking at the national positions as I have, you'll see there's a more of a sliding scale. And certainly when you look at cyber powers, the states with the most advanced cyber capabilities, it's not necessarily the case that those states, however you rank them, and there's been lots of great scholarly attempts, the Power Cyber Index, to rank these capabilities. When you look at the top end of those states, it's not necessarily the case that all of those states are seeing sovereignty as this definite rule. And some states, when they talk about sovereignty in a cyber context, Russia and China, I'm thinking about, for example, here, they're talking about extremely different things. They're talking about the control of information, for example, internally across borders, and not this rule that we're discussing. But that's all I have to say.
So I don't want to violate my own rule of involving the audience early and often, because we haven't yet. So if you have questions, just raise your hand and I'll pull you in. And I see several, which is great. Just very quickly before I go to them, any other points, responses from anyone else on the panel to the things we've discussed?
On sovereignty versus rule or principle, I actually would say for our purposes today, that's not the most important topic. I want to continue the discussion with you, Jack, but I think the majority of states would find a primary rule of international law, not always the same primary rule, violated by certain kinds of malign influence operations. And I think the majority of states would say if it rises above a certain level. Now, your question at the very beginning was, what's that level? Not sure we've answered that, but
Yeah.
it's at least de minimis, isn't it? Because I think we'd all allow that there could be operations that have negligible or de minimis effects that wouldn't be violating international law. But whatever rule you look at, you may get to a point where you think something is unlawful, and then Talita's comments about countermeasures become instantly very relevant. The last thing I'm about to say was just in response to what Amit said, and the whole communications sort of structure is about provenance. And there's some sort of tension there that anonymity is really important, but for the right to receive information, there may be a right to know the provenance, where the information is coming from. And here, if we're talking about wrongfulness, surely what we're talking about are covert operations which hide or mask the provenance. And that's why they're suspect. And that's why I think we want to be we want to be concerned about it. It's the very nature of the hidden nature of the source, which may be impairing human rights, but also is, in a sense, offside in terms of relations between states.
Yeah, I mean, that was sort of the focus of my thinking before. There's still a scale or a scope issue to take into account, which is challenging. And as Talita pointed out, if you look at it, the notion of coercion even more broadly, it isn't dependent on there being a deception element involved, right? So, but that also then, as is often the case, flies in the face of long-term state practice. And so those are challenges. The other thing, when you're talking about scale, et cetera, there's also the question of consequence. And is there an attempt notion of prohibited intervention that would allow for taking countermeasures, which we know you can't take anticipatory countermeasures, or at least that's the prevailing view. So even more complications, but there were a number of hands.
Sorry, Gary, I think Talita has a.
Oh, Talita, go ahead, sorry.
Hand raised.
Yeah, just very quickly, I wanted to come back to a point that Amit made about and the earlier discussion that we had on this dual nature of the right to freedom of expression and freedom of information, the right to communication more broadly, and how anonymity plays out in that context, but also the right of recipients or audiences to receive truthful or accurate information. So this notion of a right to truth or accurate information is not really that straightforward, at least not in the context of international human rights law. The ICCPR, for example, like there isn't, it's not clear that such a thing exists, right? Though the European Court of Human Rights has sort of like suggested that this is the case in the context of a few cases, it's not something that is very clear or well established. What we have is, on the one hand, you've got the right of individuals to impart information, which includes information that is not necessarily true, like false information. You can spread a lie. You have that right. And on the other hand, individuals on the recipient side of things have the right to be exposed, to be freely exposed to, the marketplace of ideas, including truth and lies, right? And so that's really the dynamic that we have. However, the information environment, and that goes into states' duty to protect the right of individuals to receive and impart information, right? The duty to protect the positive dimension of the right to freedom of expression. What we have is the duty of the state to guarantee that individuals, both speakers and audiences, have a balance, a robust, a free information environment that is not so polluted that individuals cannot tell truth from lie. So that's basically it. So we can't just say, oh, individuals have the right to just hearing the truth, or individuals have the right to lie, and that's absolute. So it's a bit more nuanced than that. And anonymity is one part of this puzzle, right? As you described, all of you very nicely, it can enable freedom of expression, but also it can hinder freedom to receive information. So you always have to look at these things on a case-by-case basis and with nuance and trying to balance the various interests at play, including within the right to freedom of expression and information itself, if that makes sense.
Just one sentence.
One sentence, go ahead.
Just one sentence. I totally agree with you. We're not in disagreement at all. The point is that when we also focus on the rights of the receiver of the information, it's, yes, of course, we can spread lies. I actually heard that recently that there's this issue in Ohio, they're eating cats. So, I mean, we can tell all kinds of stories, you know, that are not true, and we don't have to be foreign actors for that even. But get back to the point. It's for the receiver. Of course, the world is full of lies, but part of assessing the value of a message. That's why I looked at the whole communication process, which includes both sides and the message that's going in between them. In order to assess the value of the message, the identity of the person that is conveying the message is part of the value and our capability of understanding how to look at the message and how to evaluate it.
Okay, hands up. All right, I think Ori, you've been patient. We'll try and get to everybody.
So actually, I was very happy to hear from Robert that you can't remember the panel last time around, because I was on that panel, so I won't sound like a broken record.
You said something about kryptonite, but that's all I remember.
So I think firstly, on the point of non-intervention, I think when we speak about, well, what exactly is the coercion, I think we're not engaging enough in the state practice which gave rise to the customary rule, and particularly when we speak about the Friendly Relations Declaration and subsequent General Assembly resolutions. We're not looking at the very deep and substantial disagreements among states as to how far they were willing to take it, and particularly Western European states, which were basically unwilling to go beyond assistance to non-state actors supporting the overthrow of foreign governments. And I think this is even reflected to a certain degree in the Nicaragua case, where what ultimately overthrew the Nicaraguan government was the American economic sanction a few years after the judgment, but that was considered by the court to be not unlawful under the principle of non-intervention. Also, just the point on countermeasures that, although whenever you try to disagree with the customary status of the Articles of State Responsibility, you're up against it, but I think we can question at least some of the conditions which are listed there as to their customary status. Certainly some of them, if you look at the special rapporteur reports, particularly Gaetano Arango Ruiz reports on countermeasures, some of the state practice which he manages to bring on some of the conditions like negotiations, and even on their aspects relating to fundamental human rights, is very, very limited. So I think we can, if the state is willing to go up against it, I think there is some wiggle room there to make an argument.
Very good.
Interesting.
The back, yep.
From Melbourne University. Rob and Jack, I wanted to ask you why in the conversation the right of people to self-determination will come up. It seems to me that it is an easier avenue to hold as unlawful election interference than non-intervention. If we recall the most agreeable definition of the right of people to self-determination, it is that all peoples, not only colonial, all peoples have the right to determine freely their political status and pursue their economic, social, and cultural development. So you have here all the elements that concern actually foreign intervention. So freely is already there, and it's not just limited to coercion, but it is really the ability to exercise your free will. And also you have all the political status, which is also a trigger. Of course, I understand that it is an unorthodox interpretation, or at least application of the right of self-determination in this context. But as the court put it, this is a right with a broad scope of application.
Either of you want to react to that quickly?
Yeah, happy to. Yeah. No, I mean, I would generally agree. I think it's interesting when you talk about self-determination in the cyber context that it hasn't played a larger role. I know there's some scholarship which has explored exactly the lines that you're presenting, but As far as I know, among states, when you look at their national positions and when they're discussing it in UN fora, it's really largely absent. But I would agree with you that there's definitely a role to play there. It just seems to be that states are focused on other rules. Yeah.
Yeah, I mean, it seems like there's a direct overlap though as well. I mean, that's the core of what domain reserve discussions are about. So it's a very interesting point. All right, other hands were up. Yuval?
Yeah, thank you, and very good discussion. I was intrigued by Rob's example on the wheat export, which I actually thought was a quite dangerous, slippery slope kind of example. Not that that works for me in any way, but I mean, the idea is, I mean, I can see why when we're dealing with election interference, and maybe with domestic unrest, and these sort of issues, a state would have a very strong reason and a justification to apply countermeasures to importance. But once you get you start expanding this, and you're now interested in protecting commercial interests, and and adding to this the fact that, you know, paraphrasing, the one man's service, the other one man's freedom fighter, one man's information is another man's disinformation. And the fact that you do not have, this is a governmental decision, so you don't need to go to a court, so you don't have any procedural safeguards. You don't have any international safeguards. It seems that if states would go down that road, I mean, whole hell could break loose, because essentially what is broadcast on American television would be regarded by Russia as disinformation, and what's broadcast on Canadian television would be regarded by China as disinformation. And they may be as right as you are about the wheat exports. So I think we have to be somewhat careful in trying to formulate what are the triggering violations that could give rise to these sort of. So it's not just the issue of countermeasures and human rights, and which is an interesting point, but also whether we have an institutional framework that can support this kind of expansive approach to self-help in this domain. Because in the end, we will have no communication systems, and then we will not survive, according to Amit.
You want to?
No, I'll let more people
Okay,
ask questions.
I saw Elise, I'm going to scan the room, but I think you had your hand up.
Yeah, question. So Gary used the term dividing line. I was wondering if the panel could tackle the question of a dividing line, not strictly in the context of coercion, but in the context of information operations. What would you say is the strategic interest of states in terms of permissible and not permissible information operations? So what type of operations should the law tolerate, and what type of operations should the law prohibit? And considering that states interpret international law in light of their national interests, this type of approach could also help us, or help you, I guess, as government legal advisors, figure out what is captured by this notion of coercion, which is undefined.
Okay, we'll collect a few up. Were there other hands back here?
Yeah, thank you very much for a very thought-provoking discussion. My name is Rob Ranger. I'm a lawyer with the Irish Foreign Ministry. We've been grappling with a lot of these issues, advising our national position paper. And I want to pick up on something that Rob referred to, which is the purported de minimis exception in the context of breaches of sovereignty. And this is something we grappled with, something that we ultimately didn't include. Firstly, we weren't sure that there was a clear legal basis for such exceptions. And there was also a concern on our more sort of operational and policy side that this could be relied on by bad actors in order to conduct lower level operations. So I suppose the question is, are you confident that this is firmly established as a matter of international law? And even if it is it a good idea to be giving prominence to this? You know, I previously worked within our national system in Ireland on efforts to codify domestic criminal law principles, and we did think about de minimis, and the result that we came to was that the prosecutors hated this idea. They thought it would be something that criminal defendants could try and use to throw out prosecutions. But we also came to the conclusion that maybe this wasn't even a principle. If someone takes a grape in a supermarket that means is that perhaps technically a theft? If someone pokes someone on the arm without consent, is that technically an assault? Or is it just, so are they not prosecuted because of a de minimis principle, or is it more just a case of prosecutorial restraint on sense? So yeah, just some thoughts, and there's a question buried in there. So thank you.
Okay, very quickly, we'll kind of go down the line and see if there are answers or reactions to the questions that were posed. And I'll start with Talita.
Yeah, so I couldn't quite hear all the questions, so apologies for just focusing on the first one, which was the one that I could hear clearly, about the conditions for taking countermeasures and whether or not they mirror the conditions laid out by the in the articles on state responsibility by the International Law Commission, whether they are customary. I would say that if you look at the practice that sort of like in which the articles are grounded, and if you look at the practice like subsequent to the publication of the articles, most of those conditions are part of customary international law. But I agree that there are a couple of them. So for example, the obligation to offer to negotiate is a little bit controversial. The obligation to, the condition to make a prior demand or summation is also a little bit controversial. The human rights one, the controversy is not really about whether or not you can or cannot violate human rights when taking countermeasures. I think there's agreement that you can't affect human rights, fundamental human rights, when you do that. And that's because of the nature of countermeasures as a bilateral kind of circumstance precluding wrongfulness. It precludes the wrongfulness between the action, the action that the injured state takes vis-a-vis the responsible state. So it can't really affect third parties, so individuals that are entitled to human rights. So that's why the controversy is about like what human rights are protected, and the extent to which those human rights are protected. But yes, there are some conditions there. There are sort of like debatable, but some are quite established. And the human rights one it's just a question of the scope. So that would be my reaction.
Thank you. Rob?
I'll answer Carl's question. Yes, we're confident about the de minimis threshold. I was reminded a few weeks ago by Margaret Walter from State Department, who's not here, that I think the US were the first to publicly talk about that. It was either the Brian Egan or the Harold Coe statement of some years ago. Obviously, it was picked up by Talon Manual. And your question is it prosecutorial discretion? I think whether you want to do a domestic analogy about a grape or a tap on the arm, if you want to go to the international scale, I think states by their practice tolerate what would otherwise be, if you like, minor violations of sovereignty or minor violations of prohibition and intervention. In practice, states put up with it through each other. And in that sense, I think the practice combined with statements of states add up to saying, yeah, not every single tap on the arm or every single grape is going to be wrongful. And I think many states, besides maybe finding a legal basis for it, find a pragmatic operational basis for it, that to defend national interests, we will use cyber effects. To use cyber effects, we may have to do things that will affect minimally other states' rights or their claim to rights. And that the system may require that in order that national interests can be protected.
Great, thank you. Jack?
Yeah, I just have only some brief thoughts on coercion as a red line, sort of national interests. I mean, yeah, circular, because obviously it depends on your position on things like sovereignty, whether coercion even acts as this red line. Then my position, it does. I see, or at least it seems very clear to me from my work, that I often come to the conclusion that states are looking at cyber operations and then trying to find international law to apply to those operations, rather than so they're working in reverse, rather than finding international law and applying it directly. You're looking at cyber operations and trying to figure out how international law or what rules might apply. And I think sometimes that gets you into that political space, that international relations space, where I'm not very comfortable. I understand where national interests are involved. That's inherent in international law. But this, I think, was where some of the confusion arises. I do think de minimis threshold is a really big problem. I was introduced, I think, as being provocative. Was it, Gary? Or I wrote
In a positive way.
in a positive way. I wrote a piece on the position of France, which took a very purist position on sovereignty, which essentially is almost any effects manifesting on the territory of a foreign state violating this rule of sovereignty. And I held it up against some of their state practice, which was announced almost a week later, which would have, in their own definition, violated the sovereignty of hundreds of over 100 states. And I was really trying to just show how difficult that is in practice, to just say there's a rule of sovereignty, anything violates it, and then you have to get into this difficult space of identifying the content of sovereignty. And for me, that's really tough. And a lot of my research is focused around that. I think it's safe to say that I'm not really leaking any of the conclusions of my report when I say almost no one can agree on the content of sovereignty. Everyone has different understanding of sovereignty. And I'm not talking about the cyber context, I'm just talking more generally. So I think forming that content and that de minimis threshold for me is very much a practice of developing the law. And then, state practice when you're very difficult, because in this area, as we've heard over the last couple of panels, you've got very active state practice of states with the capabilities to do so, I would say, carrying out operations.
Thank you. All right, Amit, take us home.
Well, I just want to refer to what Yuval was saying. We have now and differentiate the problem you were raising from the issues we were dealing here with. I'm now involved in my civil activities position as chairman of the Association for Civil Rights in Israel with the case of the blocking of the Al Jazeera broadcast into Israel.
Okay.
So clearly, that's a case that, like the examples you made of Russia and China and the U.S. and Canada and so forth and so on, that is already again the right of individuals in the state to freely receive communications and to be able, since does come with the Al Jazeera logo, to be able to appreciate whether they believe it or not. It's a totally different position than the situation of anonymous information, or information that is not just anonymous, but also clouded as coming from a different source. And then it doesn't allow individuals to fully appreciate and analyze its value.
Great, thank you so much. Sorry we went over a little bit. We are finished. Let me thank the great remarks from the panelists, great questions, and lunch is upon us. So it's always good. Thank you.